If you've ever wondered what happens when someone dies without a will, this is the video for you. I've spent hours researching this topic so you don't have to, and some of what I've uncovered may surprise you. So jumping right into the basics, a will is a legal document that gives you the final say on what happens to your assets after death. Basically, having a will means that you and not the courts gets to decide who gets custody of your children, gets a share of any real estate that you may have, gets your bank accounts, your car, and other assets. And it allows you to choose who will be the executor, which is basically the person responsible for carrying out the directions in your will to make sure the assets pass to your beneficiaries. Now you're probably wondering what happens if you die without a will. Well, here's an example.
A dilemma facing millions of Americans is what will happen to their lives and their legacies if they don't have a will and other estate planning documents. CNBC senior personal finance correspondent Sharon Epperson tells us how the family of a famous movie actor is now trying to figure that out.
Black Panther movie star Chadwick Boseman lost his long battle with cancer. Now his wife must contend with courts to determine what happens to at least part of his estate.
You worked your whole life to accumulate your property. You want to make sure that it goes to the people you care about.
That may not happen without a will. Boseman died without one, leaving nearly $939,000 in his estate in what's known as probate, a legal process that distributes assets after death.
Unfortunately, Chadwick died intestate, which is the legal definition of dying without a will. While you may assume that your assets will go to your spouse, the intestate rules applied by the probate courts vary from state to state. In Tennessee, for example, if you have 2 or more kids, your spouse only gets a third of your estate, and the rest will be split between the kids. Try keeping up with your mortgage payment when you only have a third of the money coming in. Similarly, in Texas, if one spouse passes away with 2 kids, but this time one of the children is from a previous relationship, the 2 kids each get half of the deceased share of the house. For domestic partners, it can get even worse. But to keep it short and simple, in most states, domestic partners get nothing unless you have a will. According to a recent article from the Wall Street Journal, 72% of non-white Americans don't have a will, in comparison to about 45% of Caucasians who do. Despite the risk, many Americans are heading towards intestacy, but you don't have to be one of them. One resource you can utilize to get a snapshot of what the rules are in your state is HairBase.com. And this is not a sponsored video. Matter of fact, this website is free to use, but you can get a snapshot of your particular situation and the rules for your particular state. Now, there are some assets where you can't include them in a will. For example, for the most part, assets which allow you to designate beneficiaries such as life insurance, retirement accounts, 401k, IRA, etc. But there are others such as bank accounts where you have a payable on death form completed and on file, and real estate property where you have a transfer on death deed. Even if you've included them in a will, they'll still go to whoever you have listed as your beneficiaries, regardless of what's in your will. So, if you've been divorced and you forget to update your beneficiaries, you really need to take another look and remove your ex-wife or your ex-husband. Otherwise, that means you're accidentally leaving them an inheritance. Things you need to set up a will. For most people, setting up a will with an attorney is relatively simple and cheap, with a cost in the range of $89 to $2,000 depending on the complexity of your assets. To get started, here's the information you'll need. Number 1, who will be the beneficiaries of your assets, or basically who your assets will go to. Number 2, who will be the executor that'll make sure that they execute the directions in your will. Who will be the guardian of your children. And the number 1 thing to keep in mind is you've got to be specific about who gets which assets. Other important things to keep in mind are the ERISA surviving spouse rights, Social Security benefits, and video wills. Now, under the Employee Retirement Income Security Act, also known as the ERISA laws, federal law mandates that your spouse automatically receives 100% of your 401k upon death, unless they sign a written waiver. And to be clear, not even if you have a prenuptial agreement will that typically be enough to waive the surviving spouse right to get 100% of your 401k, unless they execute a separate document waiving their right to do so. Now, as for Social Security, if you're the surviving spouse, you can collect the deceased Social Security benefits provided you're age 60 or older, and children of the deceased can also collect if they're under the age of 18 or in school up until the age of 22. And lastly, video wills aren't accepted in any state in the US. Now, I've also created a wills cheat sheet which you can download via the link in the description for free. And in my will cheat sheet, I give you a summary of not only this video, but it also explains what to do after you create a will. For example, where do you store the will given that digital copies or duplicates aren't accepted by the courts. Now, that's all the time we have for today in this video. If you got value out of the video, please don't forget to hit that like button and consider subscribing. Till next time, peace.